Oh, we've got
Hello, Jeff Manishen.
Jeff Manishen. It is Mike Richards calling. How you doing, my friend?
Wow. Is this any good?
Wow.
Mikey, I want to be with you. Okay. Every time I hear Dirk Hayer's interview, I'm waiting for the song.
And take your picture. That's what.
Yeah, you're making me so horny.
Yeah. Okay, that's probably not good for your business.
Well, no, we'll cut that part. We'll cut that part.
Not that you don't charge that way. I'm pretty sure.
Oh no. Oh, hey, homie, don't play that way.
Well, Jeff, we're going to talk about another homie today, and according to what you do. Now, by the way, just so people understand your background and your resume, you're now at Ross McBride, but the person I'm talking to right now, in the legal sense, has had a very substantial career. I want you to tell the folks today what that background is.
Sure. I started, I articled for Eddie Greenspan. It was a criminal lawyer of great renown in Toronto and basically in Canada. I think he was one of Canada's foremost criminal lawyers back in the mid-'70s. In 1977, I joined the Hamilton Crown Attorney's Office, and I practiced as an assistant Crown Attorney doing everything from murder on down between 1977 and 85. I switched over to the defense side in 1985, and I've been practicing full-time criminal defense law since then. Everything from murder on down.
So this I wouldn't say you're familiar with it, but I would think sometimes when people from looking at the circumstance of 1994, 95, there's an assumption, and again, most people really don't understand the law. Those that come near it really isn't to the degree that we'll be talking about today. But there's always this weird assumption that somehow because of fame, this is why the original sentence looked the way it did, and maybe also why we think today that he's going to get parole because it has to do with who he is. Can we buy into that at all, or is that absolute garbage?
I think that with respect to the sentence, it wouldn't shock me at all if there was an element of, gee, he got away with one, so this will be a make-up call. Okay, we're talking about the conviction, the sentence, the 30-year sentence for the robbery convictions?
Yes.
Yeah, you wonder, in the States they have sentencing guidelines, and there are a number of components that direct the judge as to what factors to weigh and what kind of numbers to impose. That's different from Canada. We don't have that here. So that may well be the case that was a factor in what the judge gave down there, but to the extent that there was a discretionary element in it, I see a 30-year sentence for that conduct, even for American standards, where they have long sentences, one would think that was pretty darn harsh. And I think a co-accused got something like 27 months. So could we allow ourselves the basis to say, gee, wonder whether or not there was an element of we will give him extra because maybe he got away with something? That's possible. That's possible. That's certainly not the way the judge should do it. The judge has to sentence based on the evidence, the character, the background, and the facts. And what the sentencing guidelines are. So it could well be that the number fits within those guidelines, but one can certainly wonder about it. Now, let's update it to the present time and the issue of the parole hearing. I mean, one of the things that, of course, is stunning is the international attendance that's given to something like a parole hearing. We know for many years, if you went back, Charlie Manson, fine, is he up for parole? He doesn't get it. There's coverage. And the others of his followers. Sirhan up for parole. Clifford Olson. Various people over the years up for parole that get some. But for a robbery, robbery parole hearings aren't news. Mm-hmm. They don't get the kind of coverage. And remember, it's not in an open kind of courtroom. I understand, Mike, they're going to be televising.
Oh, it's going to be ESPN, I think, is doing, and most of the radio stations that I know that are news talk, they're going live at 1 o'clock. They're going to cover it live on the radio.
And let's go back and say, and so what's the issue? A guy has done 9 years of a 30-year sentence where he wasn't the guy with the gun. The guys with him were. And, the guy, one of the guys who was convicted with him, as I understand, got the conviction reversed because of the publicity and the fame that was associated to O.J. But, of course, in the last couple of years, between the TV drama and the 5-part documentary, it's hotter than ever. Yeah, so O.J. Simpson... I mean, Mike, you know better than me in the world of media, and boy, don't we see it these days, the colloquialism, if it bleeds, it leads. Mm-hmm. Anything that's sensational, we got to fill content. Isn't that part of the function for the media these days? Fill content. So this is great. This is content, and we get viewers. We get eyes watching the broadcasts. We get people reading or following it online. That's what we got to do. So great. It will get that sensational coverage. But, if you think about it, so the guy has been in for 9 years. From what I read, he had a parole hearing in 2013. And you can correct me if I'm wrong in terms of the information, but I read it somewhere. He had a parole hearing in 2013, and they reduced his eligibility for parole to now. I don't know if you read that or saw that anywhere.
Yeah, I'm not familiar with. That I don't
yeah,
know.
That
I don't know.
And it's different from our system. We don't have that. For us, when somebody is up for parole in Canadian jurisprudence, once you've done a third of your sentence, you can be eligible for parole, and they may have a hearing a few months before that.
Now, in terms of changing that time, because I know that here in Canada where they're talking about Bernardo, and that his coming up, but he is delaying it, and I just wondered, is there an advantage? Like, why? And I know we're sort of taking a sidebar here, but why would one delay it? Because it just seems like inevitable that it's not going to happen for him, and maybe it never does, at least for the family. But what would be the advantage in trying to delay the actual hearing?
I guess you'd figure, what's the point of going through the exercise? Okay, it's just a waste of time for everybody. And so it's not uncommon where people can kind of sense the proverbial landscape and say, no, I'm not going to get it anyway. I could have my parole hearing now, I'm not going to bother.
Right, okay.
So, and I think, and that's not uncommon. You say, gee, I don't need the publicity, I don't need the attention, I'm not going to get it anyway, I'm not going to bother. So it's not a matter of an advantage so much as just why go through the exercise.
Right.
So that's what I would figure. But as I say, in Canadian law, you're eligible to apply for parole unless there's an order making it longer. And we'll leave aside murder for the moment. Okay, but I take a robbery case. You get a 9-year sentence for a robbery, and I would say to you too, by the way, Mike, in Canada, the conduct that gave rise to his 30-year sentence there, it's not close to that up here.
Right.
Here, what would he be looking at with no record? And, that's the reality of it, is no record. And he's a party to a robbery, which is at gunpoint. Ostensibly, he says to get back his memorabilia, and he pleads not guilty. What's he going to get, 5 years?
Right.
Okay, and on 5 years, he's eligible for parole at a third. Now, with it being offense involved violence or threat of violence, he might well not get it, and he might well have to go until 2/3. And on 2/3, then he's going to be out on mandatory supervision. Okay, that's the way it would work in Canada. In the States, my understanding is that your parole eligibility is that once you've done something like 85% of your sentence, that in the States, his parole eligibility would otherwise normally be far closer to like that 20, past the 20-year mark.
Yeah.
But I guess I don't know the nuances. I don't know how he did it, and I don't know even if I'm accurate, but I read something in the paper that indicated in 2013 he applied for parole and he got it, and they said he would be eligible effectively, I think, October of this year. So it may well be that in Canada, the way that would have to happen, he would have had to appeal the sentence, have the sentence reduced, and that would effectively reduce his parole eligibility. In the States, the way I gathered this article, it seemed to indicate that he had a parole hearing in 2013, and they knocked back the time when he'd be eligible to apply, which gets him to be able to apply now. Because 10 years on a 30-year sentence, that's closer to our kind of numbers. Yeah, and that's not normally the way it works in the States. But I believe, from what I read in the paper, and didn't Will Rogers say, all I know is what I read in the papers, right, that something happened whereby he's been able to get an opportunity for parole earlier.
Interesting. Jeff, good morning. Great talking to you. We do know that the victim in this case will testify for O.J. Simpson today. When you hear the victim testifying for O.J. or whoever the case is against, does that almost tell us as an audience that this is a mere slam dunk that he will be released today?
That's a great question, Dave. I'm always reluctant in anything to do with the justice system, and we will characterize a parole hearing as fitting within that, although there isn't a judge presiding. It's a parole board. Okay, so there are, I think, 4 members that are constituted down in the States for this particular parole board, and if they need 2 or 3 more, the input of 2 or 3 more, they can supplement it. Again, that's what I've read. I'm always reluctant to talk about a slam dunk because you don't know the personalities and the views of the individuals who are going to be deciding it. And so I never like to say to any kind of client, oh, yeah, for sure we're going to, win this. Never. Partly because I'm superstitious, but also partly because you never know. But I would say this, so many times in parole hearings and in Canadian jurisprudence, the victim is allowed to have their say at a parole hearing. And, of course, far more often the victim says, I'm still afraid, this is still upsetting to me, I'd worry if he got out, et cetera, et cetera. To have a victim say, look, I don't have a problem with him getting out. That certainly is a very positive factor for him. Not only is it the absence of a negative, in other words, it's not the case of the victim not being there at all. If you have a victim saying, for my part, I'm okay if he was to get out now, assuming that was to come out, that's a very important thing for him to have, or his lawyer to have to rely upon to help him, help him with the shot of getting out. One feature that's important to keep in mind too, and the question of what role does the victim have, and certainly our laws now permit it. The time to be able to deal with the potential for we'll call it the punishment, the sanction of the behavior for the individual. Okay, potential rehabilitation, public reaction to the offense, need to repudiate the behavior, need for deterrence and all, is at the time of sentencing. And we allow for victim impact evidence to be an important part of the sentencing process. What about at the parole stage? Well, the parole has to do with, we're trying to say, can the person safely be released from the community, subject to restrictions and controls on his or her behavior? Well, if the victim says, 10 years ago I was robbed, it was scary. Well, how much do you weigh that into the risk now? Mm-hmm. One might say it doesn't really directly connect to the issue of the parole.
Well, does that mean, Jeff,
permitted? How do you weigh it?
Jeff, does that mean that really what we're talking about here today, when it actually comes to all those cameras in the 2-hour probably pre-parole hearing that they're going to have in the 5 hours afterwards to break it down, could this actually be a very short circumstance in terms of the actual minutes that we're talking about, that it's deemed that he will be paroled? Will this be relatively short?
I think that's possible. I think that if you have, for example, let's walk through it. So the victim says, look, I don't have any problem if he was to get out. And I believe, again, this is what I read in the paper, there was something to suggest that the district attorney who prosecuted him could potentially provide a report input or otherwise, and I don't think that's going to happen. I'm not sure if it's because the person's passed away or they just aren't going to do that. But what they'll do is the board will have the reports available for how he's been within the institution. What kind of activities he's done? Has there been anything in the way of any kind of discipline? Has he done programs he's needed to do? Has he been a model inmate, as we seem to have heard, and so forth? What do they have in terms of a release plan for him? If he's to go into the community, where's he going to live? What's he going to do, etc.? And the opinions of any psychologists and correctional staff and so forth. The kind of reports that will be needed for a parole board to decide the potential issues that will relate to, do we believe it's we'll call it a manageable risk? Do we feel that if he's going to return to the community, subject to controls, that can happen with a proper level of safety for the community?
Well, I'll tell you.
That's the issue.
I'll tell you what I've learned here today, Jeff, with our time. I know what I've learned today. I like to do that. I like to recap on the things that you've said and what I've taken from it. And it's this. And speaking specifically to Canada, I'm going to start stealing stuff. I'm going to start stealing stuff because after you told me what goes on and basically what I'd be held accountable for, 5 years, I do some good time. I might even only spend like a year with good behavior. So why not steal? You could represent me. I could go in. You know what I'm saying? I think I get.
Wow, Mike. Yeah. I not only, and again, I'll speak as a former Crown attorney. I'll speak as somebody who's in court all the time.
Yes.
The disruption on your life if you went out and committed some offenses. And I'll give you, let's take, for example, theft. You want to raise that, okay?
Yeah.
And for the sake of our discussion, let's say it's theft for which you get a year in jail. Do you like going to the States, Mike?
Yeah, I do.
How about never getting to go again?
That would hurt me.
Oh, really?
That would hurt me very badly.
Okay, so what do you think, again, with respect to the theft part? Because I will tell you that the U.S., if you commit an offense, that they use the phrase a crime of moral turpitude. Literally, that's the language they use.
That's
turpitude, not turpentine.
That's a big word.
An offense that has, I like to say it like Sheldon Leonard would say it.
Oh.
It's a crime of moral turpitude. You have to say turpitude. You have to say it with the New York Act, turpitude, okay? Turpitude doesn't cut it. So turpitude, a crime that has a crime of dishonesty like theft would fit. And if you got a jail sentence, even 30 days, you would be ineligible for travel to the United States indefinitely.
That's not
You'd have to apply for a waiver to get in. Think of that as a deterrent for you committing a crime. And how about if you've got no record and you'd like to get a job, but now you have a record? Do you know the number of places they ask you got a criminal record? You can't get a job? So let me say to you, as a member of somebody participating in the justice system, I would never encourage anybody, directly, indirectly, or otherwise, to commit a crime. I'd like to discourage them.
Well, then I better check.
At my job, you'd come to me saying, look, I've screwed up, I've gotten in trouble, what can you do to get me out of this mess? And the stress I see from clients who have screwed up, okay, it's very real. And it's a very real challenge because it can have a life-altering effect. So I use the phrase sometimes, Mike, have the mythical criminal lawyer on your shoulder when you're thinking of what to do. You say, gee, what would my mythical criminal lawyer advise me? Should I or shouldn't I?
Okay, well then
it doesn't help to say.
What I'm going to do now is I'm checking Russell Graham's background, because we did not do that, and I have a feeling that he has stolen in his lifetime. I'm just saying. Yeah.
Gosh,
Yeah.
that's good background.
Yeah. Hey, Jeff, thanks so much for joining us here and explaining sort of things that we obviously couldn't. But it just sounds like, at least in your opinion, if the sentence was a make good, but I think also in this, with what should have been 30 years ends up being like, 8 and change or 9, there's I don't know. It must make people think, of the legal system south of the border. That, I mean, that's really wonky. I mean, that is.
Well, the way it phrased it is this: 8 or 9 for that is more than plenty. That's number one. Number two, if he gets parole now, I'm going to suggest to you, I don't believe it will be because of the fame. In fact, I'll venture to say it's going to be in spite of the fame. It's going to be in spite of the fame, because a parole board member is going to say, gee, there are going to be members of the public saying, how can you let this guy out when everybody knows he was a murderer? Think of that. Be the parole board member for a sec. And you're going to have to use your, I'll call it strength of character, integrity, to say, no, on the test I have to apply, and on the evidence I have before me, and applying the law with respect to whether somebody should or shouldn't be released, he's a good candidate to be released. I mean, do I think on everything that I've read he is a good candidate to be released? Like, should he get parole? And what I've read, it looks like it.
Yeah.
It looks like it, yeah. Yeah, okay, and I'm going to park the issue of the fame. I'm going to park the issue of any beliefs about what happened in the past, and I'm going to apply it objectively. And isn't that what we want from a justice system?
Well, that's
just apply it objectively.
What we hope for. That's what we hope for.
Yeah, that's what you want. So if you apply it objectively, you say, all right, on the objective information we have, is he a good candidate to get parole? Yeah, he is.
Jeff,
so
thanks.
We'll see what they do.
We've got to run here, but appreciate the time, my friend, joining us and explaining those things, and hopefully you don't see me as a client at some point.
Well, and in fact, let's do it this way, Mike. Okay, I'm still waiting for my theme song. Okay,
all right.
I want my theme. Law and Order theme doesn't cut it. I want a lyric. You can pick the parody, and we'll find other law topics in the future, because it's so much fun talking with you guys.
I'm sure it is. Hey, Jeff, you take care. Thanks so much. We'll talk to you again soon.
Okay, best regards, guys. Good chatting, Dave. Bye.
That is Jeff Manishen from Ross McBride, who I believe has just completely, in every circumstance, told us every single element of what is going to happen today.
What? Did we just become best friends? Yep.